Thank you. Mr. Chair, members of the committee, Jim Ewart with the California Newspaper Publishers Association. Also on the issue of the delay, that's one of our concerns with the existing language. And the legislature, in its wisdom, created a default for the response time for an agency with respect to a request for information, and it set that at 10 days for a reason. Because agencies have a tendency to drag their feet, and we still experience that today, even with all of the exemptions that apply, as Mr. Cervenka pointed out in earlier comments. But the legislature also contemplated that there are circumstances where that 10-day period will need to be extended. As in this case, with this material, with this information, that can readily be asserted by any of the agencies as well, if there is an investigation that goes beyond the 10-day period or for an extensive period of time, if they have trouble locating a record and the like. So we think that if every other state and local agency in California can abide by the 10-day period, that DSS and the counties, with respect to requests that arise in this area, can also abide by that. Secondly, our concern with the summaries of information. I guess we have a fundamental philosophical difference with respect to treating near-fatality information differently than information about fatalities. From our perspective, the information that the public should get about near fatalities is probably even more important than information about fatalities. When the fatality occurs, it's over and done. Everything is in the rearview mirror. Everything is being examined as to what could have happened. When a near fatality occurs, it's very likely that a fatality may follow. And so it's important for the public to understand how that could be prevented before the death occurs. We think that there are adequate protections in the law right now with respect to the redacting of personally identifiable information that allow the public to see these source documents so that it can make a determination as to what could be done before that tragic death occurs. Summaries just don't do it. And while we're encouraged that there may be some proposal that summaries are provided in addition to the actual source documents, as Assemblymember Chu discussed earlier, we think that's a great idea because it does give context to a situation that the source documents alone may not provide. So we are very much in support of that proposal. Lastly, there is a provision in the language that would allow for the redaction of all information about an adult involved in the case that was not the direct cause or directly linked to the near fatality or to a fatality. And while there may be circumstances where that's appropriate to protect privacy of not only the minor involved or others in the family, siblings in the family, because the language is written so broadly, it applies to the caseworkers and the social workers as well. We don't think that that's appropriate. They are overburdened. They have huge caseloads. And part of the story is understanding that. And there may have been decisions made on the basis of those huge caseloads where they didn't have enough time to properly assess the situation, or they reacted in a certain way. And it's important for the public to understand that. So we would urge that that be removed or at least tightened to recognize the circumstances under which the information about an adult that's not directly related or linked to a near fatality or fatality is redacted. We also look forward to working with the group this afternoon in hopes of resolving these issues, but if that doesn't happen, we are hopeful that this committee will understand and respond to our concerns accordingly. Thank you.
Thank you. Mr. Chairman, members, Ed Howard, Senior Counsel with the Children's Advocacy Institute at the University of San Diego School of Law. First, on a personal note, I want to sincerely thank the Chair for his comments at the beginning of this discussion. The reason why passions run high on this issue is because not only are we talking about abused and neglected children in the first place, we're talking about abused and neglected children that the system, one way or another, may have failed in the most dramatic way possible. And So I would like to talk briefly about two things, please. The first is to talk about the stakes when it comes to public disclosure of the original documents. And the second, to talk a little bit about the issue which, as you can tell, most philosophically divides the parties, which is the issue of original documents or summaries. As to the first, as also one of the original drafters of SB 39, along with pretty much everybody who spoke on both sides of this bill, actually, one of the things that we have learned over the last 8 years of experience is that the existing checks and balances are inadequate without public disclosure, are inadequate to ensure the safety and well-being of our abused and neglected children. And that's because in counties such as Sacramento and Los Angeles, where reporting, because you can look at source documents, has revealed systemic failures of those systems, subsequent commission reports and subsequent audits have revealed for the first time, notwithstanding the existing checks and balances, dramatic problems with the delivery of those services and prompted dramatic reform. The Blue Ribbon Commission that was impaneled after the Los Angeles Times provided an expose about the tragic death of 8-year-old Gabriel Fernandez, who was visited 6 times by social workers. That Blue Ribbon Commission declared nothing short of a complete rethinking about how the county ensures safe and supportive care for abused and at-risk children will lead to the seamless and comprehensive child welfare system that the county has needed for decades. The Commission noted that on our watch, many of Los Angeles County's most vulnerable children are unseen, unheard, and unsafe. In 8 months of hearings, hundreds of hours of testimony, the Commission never heard a single person defend the current system. An audit of Los Angeles County that, again, all came about because of the reporting that was able to look at source documents and detect this not as one rogue social worker being a problem, but as a systemic failure. The audit, quote, of a Bureau of State audit found in 13 of 15 child fatality cases investigated, 13 of 15, front-end failures were identified as a contributing factor to the tragic ending. But it wasn't just Los Angeles County. Oh, and by the way, the Bureau of State audits also found something else, that the county was placing abused and neglected children in placements before they had checked frequently whether or not they were safe. The BSA said nearly 900 children lived in homes of relatives that, once assessed by the department, were determined to be unsafe or inappropriate. In Sacramento County, after a spate of truly tragic child deaths, again, revealing systemic failures because you can look at the original files, Sacramento County hired an outside monitor to look at the employment manual of the social workers. Quote, the county's guidelines, this is from the report, outside monitor report. The county's guidelines for its social workers contain 167 policies spanning more than 1,300 pages. Over 60% of these guidelines were last created or updated more than 5 years ago. That's the reason, in part, why when you actually looked at the files in Sacramento County, the original documents, you saw stuff that was all over the map. Your employment manual was 1,300 pages. That means there is no manual, sir. So the stakes are very high here. The reporting that can identify systemic failures, which you can only do when you look at source documents, has led to life-saving change, revealing dramatic inadequacies in the way that we treat these kids, and has prompted sweeping reforms in at least a few of our counties. So that's the stakes. Now, I do want to talk a little bit about the summaries and the privacy issue. And if I can conclude on the stakes, I'm sorry. The failure of the system failed as much if the kid is horribly beaten but manages to pull through, as opposed to succumbs to their injuries. In both instances, we have an opportunity to take a look under the hood and see whether or not this was an isolated and tragic incident, because social workers doing this job have the hardest job of pretty much anyone I can think of, or whether or not it was a consequence of, an employee manual that was 1,300 pages. So going to the issue that really separates us and that has to do with the summaries, let's first, before we get to the summary, do a little bit of a stroll through, both in SB 39 and under this measure, the hoops that have to be gone through before any disclosure is made. The first is that The death, as tragic as it may, or the injuries, as tragic as they may be, even permanently disfiguring injuries, may not actually qualify as a near death. So the first hoop is they have to satisfy the legal definition of near death. The second is the near death has to be caused by abuse and neglect. And further, under the proposal, the abuse and neglect has to be ratified, has to be substantiated, either by someone in law enforcement or by Child Protective Services itself. Two hoops. Third, and this is very important when talking about the privacy of this kid, of all of the kids who were alive, there's a requirement in this bill, just as there was in 39, that counsel for the child has to be notified before the release and provided an opportunity to object and keep the release from occurring. Likewise, under this proposal, all information that is privileged or confidential under any other law, that has to be redacted. Law enforcement has to be provided an opportunity to stop the release before it comes out in order that we not imperil an ongoing criminal investigation. And on top of all of that, all identifying information, not just the kids' names, every proper noun, including names of hospitals, every proper noun is redacted both under this proposal as it has been under SB 39. And I want to reiterate what Mr. Grimm said. I've probably seen, I've lost count of how many files I've seen. I myself am unaware of any circumstance where the redaction and all of these similar analogous protections for the last 8 years has failed to protect the identity of kids. And that was the same argument we heard way back when we were negotiating SB 39. It was the same arguments. Why not just go to court? Well, the reason to go to court is because, as my friend said about litigation, the worst thing about litigation is that it's only arbitrary some of the time. You don't know what the outcome will be any time in court, and it's expensive and time-consuming and unpredictable. Well, what about, we heard many years ago, the interests of the siblings who are still alive? They might be identified. Redaction has solved that. What about the embarrassment of the parents whose children have died? Redaction and the process I just went through have solved that. And then finally on the summaries, and thank you so much for your indulgence, how do you summarize something that is already a summary? When you look at case notes, it is the summary of a social worker's observation about what he or she saw out in the field. They're already summaries. In order for those to be summarized, it's one, entirely redundant. Two, the proposal is silent on the qualifications of the person doing that summary. Three, the law is silent on the independence of that person doing the summary. We're not talking about placing someone in a conflict of interest doesn't mean that they're a bad person. It means they're a human being. If they have to issue bad reports about their colleagues or superiors, that's just a problem. So we do hope to be able to come to a resolution, but the reason we're passionate about underlying documents is because when you look at them, that's when you see there are systemic problems, not when you have a summary. Thank you so much for your time.
Thank you. I've allowed the public comment to go on longer than I normally do. Those of you who come to this committee know my reputation and that we appreciate brevity and insist on it because these issues are complicated. And we're not going to resolve them in a few minutes or in a meeting at 2:30. And even if we reach an agreement that all parties find reasonable or satisfactory, the sad reality is that children in this state and in this nation will still be harmed. And we've got to make that our top priority, how we will prevent children from being harmed by abuse or neglect. And so we will continue this conversation into this afternoon's meeting and in other meetings as well. And this committee will be a hearing and a vetting place for hearing the various arguments that we heard today. What I would put out for myself is an expectation that we never waver from making children and their safety the focus of these conversations. This cannot be about trying to figure out who to blame, because the reality is by the time the child gets to the child welfare system, our society has already failed them. We have allowed children to be abused and neglected that carries trauma that will last them likely their lifetime. And so, but while accountability is important, and I insist that we have accountability, we must consider that by the time a child has reached our system, our society has failed them. They have been abused and neglected, and they will carry trauma probably for their lifetime. So we must separate out the facts. And I have no doubt that anyone in the media would release information that will harm a child. I'm confident of that. I do still have the concern that circumstances may be different from 8 years ago when these guidelines were first created, because now we have seen that people become identified even when they don't want to, simply by a description of circumstances involving the individual. I'm not expressing an opinion yet on what should be the final guideline, but I'm just stating a fact that we know now. Everyone has become an on-the-spot reporter on Facebook and social media and has identified people who don't want to be identified. And we must carry ourselves with the greatest care and caution for protecting children who've already been hurt. And so I'm asking that this committee, as it meets today, take up these kinds of concerns. How do we balance the need for accountability and transparency with the need for protecting children and protecting children going forward? That we make it less about blame, we make it about creating practices that will protect children going forward. This committee won't take action on this matter today, but we'll continue to hear it. Many of us will be participating in this working group that will have its conversations. And again, I insist and urge all who participate to make the protection of children be the constant focus of where that group will go. Again, I'm going to go back to the committee members to see if there are any questions or other comments from members of the committee.
I just hope we figured it out in my absence. Did you figure it out, Mr. Chairman?
We figured it out that we haven't figured it out, and that we're going to keep working at it until we can say that we've kept all of our children safe. I do want the department to address some of the things that came up, and they don't all have to get concluded today, but I believe that those who have opposition to the language have raised questions that do warrant some explanation. And if there's rationale, provide the rationale. There were questions about the timeline. And as you stated, Mr. Cervenka, that moving from 10 days to 30 days, 30 calendar days, there were questions there. If there's rationale, provide it. If not, I think there's an issue that will need to be addressed. And so whether it happens today or it happens in today's committee at 2:30 or going forward, I do think that all questions need to be on the table as we strike to find balance between transparency and ultimately protecting the lives and the well-being of our children. Anything that you wanted to close with as it relates to what you heard today?
We're committed to pursuing the process. We appreciate the committee hearing this. We know it's complicated. We know it's confusing. We know it's contentious. And most importantly, we know it's very important. Thank you.
Thank you. We'll look forward to the ongoing conversations on this issue. We're moving back to issue number 2, approve relative caregiver program parity.
I'll be very brief on this issue. The administration retracts its May revision trailer bill on this proposal. We expect to have replacement language later today or tomorrow at the latest that addresses the concern and properly reflects our intent. In a nutshell, it's been longstanding law that resource families in California receive a full AFDCFC rate. Our language disrupted that. We were unintentional about it. We made a mistake. We own it. We're fixing it. And we will make sure that it's cleared with advocates and other stakeholders as well before it comes to the committee again. I apologize for the error.
Thank you. Department of Finance, LAO's office, public comment. Any questions from committee members? Seeing no public comment, we'll move on to issue number 4, continuing with the Department of Social Services, tribal approved relative caregiver program.
So as the legislature recalls, the approved relative or caregiver program, otherwise known as the ARC program, was established as a means of increasing the rates paid to relatives who are caring for non-federally eligible children in California. It's an optional program to which counties can opt in, and they receive funding for the caseload of non-federally eligible children being cared for by their relatives. Previous to the ARC program, those families received only a CalWORKS grant, which was significantly lower than the foster care payment. But in the construction of the ARC program, there were additional complications identified for tribal cases. We believe this language accurately resolves it, and no concerns have been brought to our attention with this language. This would allow the two tribes in California that have Title IV-E agreements to receive ARC funding as well for similarly situated kids. So this basically fills a gap left behind when ARC was created, and we have heard no concerns on this piece of language.
Thank you. Anything from Finance? Anything from the LAO's office? Committee questions? I would just reiterate one that was in the staff briefing, the list of questions. Has there been input sought from tribal representatives about these practices?
Yeah, they were aware that we're working on this language. They were consulted, and they had no concerns expressed to us, and they were in favor of the creation of this because it is better for their families as well, should they choose to opt into the program.
Thank you. Is there any public comment on this item? Public comment? Seeing none, thank you. We'll move on to issue 5, Fair Labor Standards Act, Regulations, Overtime, and Compliance. Continuing with the Department of Finance.
So we had a long discussion last time in front of the committee on the issue of FLSA implementation in the IHSS program overall. I'm not going to rehash that unless the committee has questions on that. I would be happy to jump simply to the questions listed in the agenda. Very good. The first question is, why is there no trailer bill proposed in the May revision to crystallize the exemptions in the new work week hours calculation? Shortly after the U.S. Department of Labor issued its final rules applying FLSA to domestic workers across the country, the U.S. Department of Justice came out with guidance and said that in light of the U.S. Supreme Court's decision in Olmstead that provides folks the right to live in the most restrictive environment in the community, least restrict. Did I say most? I'm sorry.
Least restrictive. You did say most. Just checking.
Wow. Yes, Olmstead, in the least restrictive community-like setting available to them, and also in light of the Americans with Disabilities Act, that any state that implemented limitations on provider availability to work the authorized hours of services needed to have an individualized exemption process to address any unique circumstances that may arise. California, we implemented exemptions 1 and 2. They're described in your agenda on the beginning of this issue, and we believe that complies with the DOJ guidance, and we therefore do not have a trailer bill proposal for you at this time. With regard to the work week calculation, with 12 months in a year and each month having a different number of days between 28 and 31, the statute in the implementation of California's FLSA provisions required that the cap on provider weekly hours be established by taking the recipient's 283 maximum authorized hours of service in the program and dividing by 4.33 as the average number of weeks. But there's only 4 weeks, not 4.33 in the month of February, for example. So our implementation guidance made sure that recipients continued to be able to receive their maximum hours of care from that same provider in a month by using the number 4. We think it's consistent with the intent that the legislature had and the administration had in enacting the FLSA implementation. There are months in which we're dividing by 4.33 because 30 and 31 days is roughly that decimal. But at any rate, the goal that everybody had in mind was to ensure that a recipient with 283 hours in a month was able to get services for that full 283, regardless of the number of days in a month. So that's why you have no trailer bill language before you on either of those issues. In relation to the lack of county readiness to implement the violations policy, there's been a great deal of very collaborative work on this. It's no secret that implementation of FLSA and the In-Home Supportive Services Program has been one of the most complex program changes in the program's history. We've had robust engagement with a variety of stakeholders as far back as the end of 2014, when we originally had planned to implement FLSA, although it was eventually stalled by court action at the last minute. There's been significant efforts to train people on the rules of the program. There have been significant efforts to train people on how to fill out timesheets correctly. Beginning in August of this year, when final court rulings enabled the rule to be effective, and we knew that we would be implementing on February 1st of 2016, we embarked on a massive collaborative effort with labor organizations and counties to develop training materials for people and make those available. They continue to be available on our website to inform them of the changes in the program. We did several mass mailings beginning in October and through December of 2015 in anticipation, announcing the new rules and providing instructions. We asked counties for assistance with consumers and providers completing workweek agreements to ensure that recipients knew when their providers were available and the providers were able to tell recipients when they would be available. Counties were also assisting consumers in finding additional providers where necessary to live within the caps on provider workweek rules. There was significant collaboration on recent instructions specific to counties on how to make system changes to accommodate implementation of the program. It's a very long list. We did a number of all-county letters on the exemptions process. We did a number of county letters on the violations process. Just yesterday, we issued instructions on how to handle violations identified in the program. Since February, we've made available data downloads to counties, and those are now being provided on a weekly basis to both counties and labor organizations, listing out, and now we're able to additionally identify the types of errors being made on timesheets so that counties and labor organizations can continue to do targeted outreach to people who are making errors on timesheets in order that they are educated on the rules of the program, continue to receive training opportunities on the program, and also to assist them in identifying any unique circumstances that can't be resolved by finding additional providers in the program. And forwarding those exemption requests to us. In terms of Exemption 1, as described in your agenda, we have processed virtually all of the exemption requests that have come to us at the department, and we did a direct mail to consumers and providers for that one, and counties continue to process Exemption 2 requests to us. There's been a great deal, as I said, of collaborative work. That's a description of just some of them. There are other things like job aids for the social workers, et cetera, that have also been developed.
Thank you. Anything from Finance, from the LAO's office?
Thank you, Mr. Chair. Callie Freitag with the LAO. We would just point out, as the department has already mentioned, they are not proposing any trailer bill for the provider exemptions that they've just discussed. So if you are interested in increasing legislative oversight over these exemptions, you may wish to consider adopting trailer bill language that's consistent with your intent for exemptions to the workweek caps. Thank you.
Thank you. Any public comment? 1 minute each speaker.
That's fine.
Thank you, Mr. Chair. Deborah Doctor from Disability Rights California. Thank you to both staff members who have been so helpful. I first want to say that I appreciate the guidance that went to the program managers last night, I think, which says that, if I'm understanding it correctly, there will not be violations processed for the month of May. I'm also appreciative that the circumstances, the wrongful denial of exemptions that I've sent to Mr. Travinker and to Eileen Carroll have been dealt with. However, I would like assurance that this form and these reasons that exemptions were denied, the first exemption, that these are not happening anymore. The department was denying exemptions based on criteria that were not part of the actual criteria. So I'm hoping to hear their assurance that that's not happening and that everybody who got a denial will have their case reviewed. We appreciate that there is a second extraordinary circumstances exemption, but it would count more if people knew about it. It would be more helpful. It would actually meet the guidelines, I think, of the Department of Justice if people knew about it and we weren't depending on social workers, some of whom are brand new to their caseloads of 300 or more, to identify the people who are appropriate. I don't think it counts as a benefit if you don't tell people about it. And let's see.
Please make your final comment.
Thank you very much for having this hearing.
Thank you.
Mr. Chair, if I may.
After public comment.
Thank you.
Thank you, Mr. Chair, members. Kathy Sunderling with the County Welfare Directors Association. We spoke extensively on the concerns that we and the larger coalition have with the overall implementation, and I'm not going to get into all of that again, obviously, in my 1 minute. We do continue to have concerns. Appreciate very much yesterday's management guidance. We do think that counties will welcome this opportunity to take the data, which is now being provided in a more usable format, regarding individuals who are violating or would have violated in May, and able to reach out to them and help correct that. We do want to have some ongoing conversations around, well, what happens going forward? Is the same person going to do the violation in June or July, or are those different people if they're violating, and how might we have some flexibility around that? And just to say regarding the exemptions, we certainly do agree with Ms. Doctor that it would be helpful for people to understand what the exemptions are. Exemption 1, there was a mailing, but there hasn't been on Exemption 2. And we urge the department to think about Exemption 2, which is relatively narrow in its construction if someone has a medical or behavioral need. Also, there's requirements that the provider live with them, and a provider serving more than one person is not necessarily going to live with all of those people. So we think that some flexibility would be helpful there, and encourage the department to consider that, and allow counties to put forward cases that they think really should get an exemption and consider that favorably. Thank you, sir.
Thank you.
Good afternoon. Kim Rutledge with UDW. I want to echo both Ms. Doctor and Ms. Sunderling's comments up to this point. As representatives of almost 100,000 IHSS providers, we are certainly still concerned with several of the issues involving FLSA implementation. First of all, we do appreciate the letter that came from the department yesterday concerning the month of May extension of not counting the violations. We would like to see that extended to the month of September, just because, as Ms. Sunderling just pointed out, the counties don't have the preparation yet and the understanding to really put forth these rather complicated and extensive exemptions, and frankly trying to get all of our providers up to speed and make sure that they're getting the exemptions that were put in place for them is taking us a fair amount of time. So I urge the committee to adopt trailer bill that will extend that grace period. Also on the subject of exemptions, I also want to echo the previous comments that we need to make sure that there is a due process for appeals if people are denied by social workers who in most cases just don't understand the rules yet. Right now, basically, the due process is a provider contacts one of their two unions, and we end up communicating with the Department of Social Services to get them the exemption if they're denied. And I can't be a one-woman exemption process, denial process right now. I have too many other things to do to deal with due process. So I think that we need a formal due process set forth. And we appreciate you having this hearing today.
Thank you.
Mr. Chair, members, Robert Harris on behalf of SEIU California. I would echo everything that that Kim Rutledge said, except for we have like 300,000. So with our 2 or 3 person trying to work through all these things, we've confronted another issue. And that issue is that we also represent a great deal of the social workers who work in IHSS, who are already way overloaded staff-wise. The stuff that the counties have gotten and that the public authorities have gotten hasn't even translated down to our social workers. So when our people call about specific cases, and they go, well, how about the System 2 or the Exemption 2? And the social workers go, I haven't even heard of that. What is that? Because the whole process hasn't trickled down to the people who are expected to implement it. And that's why we think it's really critical to give an extension beyond this 1 month thing. So we would ask for trailer bill language to do that.
Randy Hicks, California's Disability Rights. I agree with everything that has been said. And I'd like to add to you, I have a friend of mine who's a caregiver, and he's a worker, and he got bumped up to be supervisor. And it's not enough that they have to fill in for people who can't do their job because they're, one reason or another, they have to fill in. So that's another reason they have another issue. The other thing is, he doesn't even know about all of this as it's happening. It's all going to be one big surprise to him. It's like, I didn't know about all this. And, when the people are out in the field, they ain't got time to get back into the shop and make them have to watch a video, make them have to learn all the rules and regulations. It's hard enough just to do the job, to fill in for people who can't, who don't show up for their shifts or who call in sick or something like that. So this is a very big issue. And if you're going to, I totally agree with the extension. You should have the extension even longer than September, because it's going to just take long enough to get the line staff to understand what you're doing, how you're doing it, and making it easy and simplified. Just say this is to what it is. And as for the exemptions things, I don't even think any of them. I know my friend. He's not heard anything about exemptions, and we know that they're the ones who are going to get hurt, along with the consumers, because they're going to lose their worker.
Thank you.
Kevin Eisen, Coalition California Welfare Rights Organizations. We also support the extension. We also would suggest it's about time people start bringing IHHS into the 21st century. There's nothing computerized. You cannot apply online. You can't request exemptions online. Nothing online. They're still living in the 20th century, and we need to start the process to bring them into the 21st century. Thank you.
Thank you. Any other public comment?